Well, so far, the Department of Justice has failed to appear in a matter, and that has led a federal judge to find for now in favor, effectively, of James Comey. It's a case involving Daniel Richman, a professor from Columbia, but in breaking news to kick off this Monday morning, Judge Kollar-Kotelly in the District of Columbia has ruled, at least through noon today, that the government, the Department of Justice, Lindsey Halligan or anybody else in the Eastern District of Virginia that's acting like it's the U.S. attorney as a prosecutor, cannot use the Daniel Richman files, which were the core, the heart of the indictment originally against James Comey, the one that was thrown out by Judge Curry because Lindsey Halligan was illegally appointed. There's been a rumor on the street, because the Department of Justice can't stop leaking and can't stop bragging, that they're going to try to re-indict James Comey the way they tried to re-indict in the last 72 hours Letitia James, the New York Attorney General. That failed in Norfolk, Virginia, and Comey's people are sitting by and I'm sure coordinating their efforts with Professor Richman. Professor Richman turned over voluntarily a series of documents back in 2017 to 2020 that were used by the prior administration to determine and the end of the Trump administration, the first term of the Trump administration, to determine whether James Comey should be prosecuted. He already turned that over. The problem is that in September of 2025, Lindsey Halligan authorized, apparently, the FBI and others to go rummaging back through Professor Richman's materials without regard to attorney-client privilege material that was inside of it, and ran roughshod over his Fourth Amendment rights against illegal search and seizure. They did a warrantless research of the material that had been sitting around since 2020. 5 years later, they dusted off the boxes and they started going through it. The problem is that Judge Fitzpatrick, a magistrate judge that sits over the Comey case, said you just violated everybody's Fourth Amendment rights, particularly Mr. Comey and Mr. Richman, because you used a warrantless search. You didn't separate or segregate any of this material, and you have violated the Fourth Amendment rights, at least, of Comey and Richman. That led Daniel Richman to file an emergency motion, right, to get back all of his material and preclude the government from using it against Comey in an indictment. And that's the ruling we have now, a narrow temporary injunction, a temporary restraining order that will expire by about noon today, waiting for the government to finally make an appearance. And then the judge is going to have a full briefing schedule on the underlying motion. But in the meantime, this will derail the Department of Justice if they are planning to use Professor Richman's material like they did to get the first indictment about lying to the grand jury, for James Comey lying to the grand jury. They're going to have to do it without Richman's material, or they're going to have to indict him for something else that doesn't relate to all of the information that they already saw in the Richman files, which have now been blocked, at least for the next day or so. I'm going to pull it all together here. Welcome to Legal AF on Monday for this breaking news. I'm Michael Popok. Take a moment. Now's the time. Hit the free subscribe button. Help us grow to 1 million before we enter 2026. It all started on the 26th of November, right around Thanksgiving, when Professor Richman filed a motion for return of property pursuant to Federal Rule of Criminal Procedure 41G. In that motion, which I'm going to post for paid subscribers on Legal AF Substack, it says the following. Between 2017 and 2020, Professor Richman, an attorney and law professor with a distinguished record of government service, had various interactions with the government relating to his representation of former FBI Director James Comey. Professor Richman agreed to allow the government to image his personal computer for the purpose of identifying and deleting certain sensitive documents, and subsequently agreed to a limited search of the image. That's back in 2017, 2020. related to Arctic Haze, an investigation related to the emails for Hillary Clinton, not whether James Comey perjured himself at Congress in 2020 or in 2023. The government later obtained 4 warrants that authorized additional searches of the image and of Richman's email and iCloud accounts. Richman was never charged with a crime, and he never got his stuff back. On September 25, 2025, Mr. Comey was indicted. Before the indictment was dismissed, disclosures in the case brought to light troubling facts concerning the government's handling of the materials it obtained from Professor Richman from 2017 to 2020. First, the government violated the warrants that authorized its searches of Professor Richman's files by failing to identify and segregate responsive materials, thus seizing the entirety of the search materials. Second, they retained the materials that it collected from Richman's personal computer, email, and iCloud, and then did a warrantless search of all of that in contravention of constitutional rules and the attorney-client privilege. That's what they lay out in their motion that then gets assigned to Judge Kollar-Kotelly, a senior judge appointed by Clinton in the District of Columbia Federal Court. Now, you move forward, they then cite to Judge Fitzpatrick, the magistrate judge, who threw up his hands and said, and let me read to you from a quote from Judge Fitzpatrick on page 8 of the motion, if a new warrant had been sought by the government and issued by the court, the Fourth Amendment would have required it to be narrowly tailored, authorizing access only to materials within a limited time frame. In addition, a new warrant would have imposed strict procedural safeguards to ensure privileged information was not reviewed by the prosecution team. You'd have a taint team established to make sure that people working on the case didn't see things they should not have seen. As a result, the parameters of the 2025 search would inevitably have had a different and much narrower scope than the warrants. Instead, the government chose to unilaterally search materials that were seized 5 years earlier, seized in a separate closed investigation, never reviewed to determine whether the seized information was responsive to the original warrants, likely improperly held by the government, that included potentially privileged communications, did so without ever engaging the privilege holders, and did so without seeking new judicial authority. That sounds like a Fourth Amendment violation, which brings us to the filing in front of Judge Kollar-Kotelly. Now, a couple of interesting facts here. The lawyers representing James Comey is a law firm called KKL in New York. Nick Lewin in particular. Who's Nick Lewin? He was the deputy chief of the criminal division of the Southern District of New York. He was also special counsel to Robert Mueller and to James Comey. So he knows what he's talking about. Now, they sent a request to the government before they filed an emergency motion for temporary restraining order, now granted by the judge, asking them to agree. Unfortunately, the Department of Justice sent back kind of a word salad of an email and did not commit to not using the Richman material in furtherance of a future indictment of James Comey. Instead, they said something quite weird after Nick Lewin sent an email to the lawyer Jocelyn Ballantyne and Mark Hansen for the government. They said, listen, let us know by today what your position is. Otherwise, we got to move on a temporary restraining order. But if you agree not to use Daniel Richman's material in your new indictment, we'll just handle it by an agreed order. So instead, she says, in response, I've shared your pleadings and request with the prosecutors, who handled the Comey prosecution out of the Eastern District of Virginia. Okay, past tense, handled, and prosecutors, there's only one prosecutor. Her name was Lindsay Halligan. We know that because we've all read through the grand jury transcripts, or at least Judge Curry has read the grand jury transcripts and determined that there was only one person who handled the prosecution, and her name was Lindsay Halligan. So who's this other prosecutor that they're talking about to make prosecutors plural? There is now a new set of prosecutors that have been brought in to work with or instead of Lindsay Halligan, but that doesn't seem to fit this particular email. That's a head scratcher we're going to have to get to the bottom of. And then it comes to the restraining order, which I'm now going to read to you again. This will be up on Legal AF Substack for your review if you're a paid member. Upon consideration of petitioner Daniel Richman's motion, the court concludes that petitioner is entitled to a narrow temporary restraining order to preserve the status quo while the court evaluates the underlying motion on full briefing and argument. In other words, I need time as a judge to let you guys brief the full underlying issue, but in the meantime, I can't let the government use the information because the cat's out of the bag at that point. That's the subject of the motion. So you can't use it for your indictment while I'm trying to get to the bottom of whether you should be using it for your indictment. She says that 3 factors weigh in favor of entering a prompt temporary restraining order. First, she says, the court has been in communication with attorneys from the U.S. Attorney's Office for the District of Columbia, and no one has made an appearance in this case. Even though the court has reached out, no one has entered an appearance on the court docket, which is weird. Second, the government has not indicated who has custody of the Richman files. And we won't know it, the judge says, until the government makes an appearance in the case. And then finally, the court finds the government has received actual notice by way of that email, right? Which we'll put up on the screen. The email exchange, Exhibit A, shows that the government is, at least this Jocelyn attorney, is on notice about the court proceedings. She then says on page 3 that the court concludes that the petitioner is likely to succeed, that's Professor Richman, on the merits of this claim that the government has violated his Fourth Amendment right against unreasonable searches and seizures by retaining a complete copy of all files on his personal computer. The court further concludes that Richman is likely to succeed because he is entitled to a return of his materials under Federal Rule of Criminal Procedure 41G. And he's demonstrated irreparable harm about the ongoing violation of his Fourth Amendment rights. She therefore orders as follows. The United States and the Attorney General of the United States, that's Pam Bondi, are ordered to identify, segregate, and secure the image of petitioner Richman's personal computer that was made in 2017, his Columbia University email accounts, and his iCloud account, any copies of those files that are currently in the possession of the United States. So you get them into your hands. They're ordered not to access that material once they've identified and segregated it, nor disseminate it. The Attorney General or her designee is ordered to certify that the United States is in compliance with this order by noon today, December the 8th. It is further ordered that Petitioner Richman's counsel shall serve this order on the Attorney General, which I believe they've done. This order shall remain in effect until 11:59 p.m. Eastern Time on Friday, December 12th, 2025. So, end of the week at almost stroke of midnight, this will stay in effect. And it's ordered that by tomorrow, the government shall appear and file a combined response to all of these outstanding papers. And a reply will then be filed by 5 o'clock on the same day by Professor Richman. In other words, Judge Kollar-Kotelly wants full briefing by Tuesday. She wants all the documents gathered up and segregated by the Department of Justice by later today. And then once she gets that briefing, she'll decide whether she wants oral argument and make the ultimate decision, which I believe she will try to do before stroke of midnight on Friday. It's a fast-moving case. Blows the entire doors off of and blows a hole in this battleship that's already sunk for the Department of Justice against James Comey. Now, there's a rumor out there, based on other reporting and leaks, that the government, Department of Justice, is considering a different indictment not involving Richman. Nothing about this order would stop them from bringing a second indictment, seeking it from a grand jury, as long as they don't use any aspect of Richman's material. And I mean any aspect of it, because otherwise we have a concept in the law called fruit of the poisonous tree. Even if it's derivative from Richman, and they only knew about it because of Richman or things in Richman, that's going to be a big no-no if it's the basis of the indictment. Now, if they come up magically, conjure up some other indictment, not involving Daniel Richman's material, that would seem to be okay. We'll continue to follow this. Lots to talk about tomorrow as things develop. I'm glad you're here on Legal AF. In about, just as a last note, a programming note, in about 2 hours, give or take, we're going to have a live presentation, live stream of the United States Supreme Court oral argument in a case called Slaughter versus U.S., in which Rebecca Slaughter not only tries to get her job back on the Federal Trade Commission, but it's one of the last links in the chain for this Supreme Court to determine whether Donald Trump can fire federal officers and agencies and boards created by Congress for the executive branch. Does that mean that Donald Trump can take them out in the back and shoot them? I mean that figuratively, and chloroform those agencies and heads and departments at will because they ended up in the executive branch, yes or no? We're going to know a lot when we hear the oral argument that starts in about 2 hours. So join us there. I'm glad you're here. Take a moment, hit the free subscribe button. Until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.